When a police officer abuses their power or a judge violates someone's rights, the law provides a way to hold them accountable. This protection comes from a legal concept known as acting under color of state law. Understanding this concept is crucial for protecting civil rights in America. Acting under color of state law refers to when officials use power granted by a government entity, even if they're using that power illegally. It covers acts done by officials under state law, local ordinances, regulations, or even customary practices. The key element is that the person is pretending to act within their official duties while actually abusing their position. This concept primarily applies to public officials like police officers, prison guards, prosecutors, and judges. However, it can extend beyond government employees. Private individuals who work with government officials, security guards given state-like authority, or even off-duty government employees using their position to exert power unlawfully can all be acting under color of state law. For example, if a police officer uses their badge to intimidate someone during a personal dispute, this can still qualify. The essential factor is whether the person appeared to be using state-granted power, even if they were misusing it. Common violations under color of state law include excessive force by police, unlawful detention or arrest, sexual misconduct by officials in detention settings, fabrication of evidence, discriminatory practices, and failing to intervene when another official violates someone's rights. The primary legal remedy for these violations is found in Section 1983 of Title 42 of the United States Code. This important civil rights law allows individuals to file lawsuits against state and local officials who violate constitutional rights. Remedies can include compensatory damages for pain and suffering, punitive damages for egregious misconduct, injunctive relief to stop unlawful practices, and attorney's fees for the prevailing party. Beyond civil liability, officials who commit acts under color of law may face criminal prosecution under federal statutes. Penalties can be severe, including fines and imprisonment up to life if the violation results in death. Officials may also permanently lose their jobs and be disqualified from holding public office in the future. The Federal Bureau of Investigation is the lead agency responsible for investigating color of law abuses. They focus on civil rights violations by public officials, allegations of excessive force, sexual misconduct, unlawful arrests, and systemic discrimination in public institutions. The FBI encourages victims to report incidents through their local field offices or online civil rights complaint portal. If you believe your rights have been violated under color of state law, there are several steps you should take. Document everything thoroughly, including records, witness names, and any physical evidence. File complaints with both the agency involved and federal bodies like the Department of Justice. Consult with an experienced civil rights attorney to understand your options and consider filing a Section 1983 claim. These legal protections are fundamental to maintaining the balance of power in our society. They ensure that those who are granted authority by the state cannot abuse that power without consequences. By understanding the concept of color of state law, citizens can better protect their constitutional rights and hold officials accountable when those rights are violated.